name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And family law issues really, of course, the obvious meaning is divorce and custody and those kind of things, but really family law issues involve any issues that impact the average family. So it could go broader than that. And we're continuing our video series today. We're going to talk a little bit about boating accidents. So please subscribe to our channel. Boating accidents were the subject matter of prior video, and we talked about the needs to be what you got to have due care when you're on the water, or you've got to make sure if God forbid there's an accident, it's going to be a question of whether or not somebody did something wrong. Is someone at fault for it? If they are, you take care of your medical needs first, contact your lawyer. We talked about that. An interesting issue was raised about who can you pursue if you're injured in a boating accident. So, much like a situation with a car, and I use a car because it's a very obvious analogy. It's not to say that laws that pertain to boating issues and sometimes maritime issues are the same as auto negligence, because there are differences, but it's an understandable analogy that everybody can identify with. Much like if you're injured in a car, you could file a claim, let's say, against the driver. Let's say the driver's negligent, you're a passenger, you got an injury. You can file a claim, and you can file that claim even if you're related to the driver. Similarly, with a boating accident, unless the policy says otherwise, the presumption is you can file that claim against a loved one. You can file that claim against a relative or a loved one who was at fault for your accident. Now you might ask, well, why do they allow that to happen? I mean, isn't it weird that a husband should sue a wife for an accident on their boat? Well, think about it. Your insurance is designed to protect you in scenarios where, let's say, you're in the car, or you're in the boat. Well, who are you likely to be in the car with or in the boat with? You're likely to be there with family. You can see a lot of boats, for example, in the marina or on the water, and who are they with? They're with friends and family. So if someone's going to be suing someone for an injury that occurred in the boat they were on, it's likely to be a claim against a loved one or against friends or family. So can you file that claim even if the act of negligence was by friends or family? The answer is yes. It's a no-brainer that if there's some stranger in a boat, and you're injured as a result of what some stranger does, if they breached duty, of course you can sue them. But the question is, if it's your own boat, can you? And the quick answer is yes, you can. Whether or not the claim will prevail, whether or not there will be a viable claim is going to depend on a lot of things. Were you comparatively at fault? What was the seriousness of your injury? Did they really have a duty to avoid doing that or to provide those things and they didn't? These kinds of things. But again, those are details. The quick answer is, though, just because somebody's related to you or friend or loved one or family member doesn't exempt them from being sued by you as a result of your injury. Now, whether or not you want to is a different story. That becomes an individual choice. But clearly, the law authorizes the negligent party to have responsibility in that scenario. If you have any questions, reach out, and we'll be glad to help you out.